I'd like to welcome you to the first full day of our conference and the first session of what's going to be a very, very interesting day. My name is Steve Patten. I am an associate professor of political science at the University of Alberta, and I've had the pleasure over the last many months to be on the organizing committee for this conference. And I'm going to be chairing the first session today. I wanted to make a few administrative announcements as we get started. For anyone who would like to have simultaneous translation, the headsets are available at registration, which is out the doors and to the left. There are also notepads available at the registration desk for those who would like to be able to take notes. Pens are available as well. This morning's first panel is titled, "How Did We Get There? Setting the Political and Constitutional Stage." The speakers on the panel this morning are Eric Adams, David Schneiderman, and Guy Laforest. The first paper will be presented by Eric Adams. It's titled, "The Constitutional Nationalism, The Road to Patriation." Eric Adams is an assistant professor at the University of Alberta in the Faculty of Law, where he teaches in the areas of constitutional and employment law. So I'd like you to welcome Eric Adams.
Good morning. Pierre Trudeau didn't like the word patriation. It was an ugly word, he said in his memoirs, a formal legal abstraction. Acutely aware of the power of words, whether in describing the Charter of Rights as the People's Package or in attacking his opponent's view of federalism as a confederation of shopping centers, Trudeau preferred to speak instead of bringing the Constitution home. This metaphor of home, spare but evocative, was designed to attract and hold the public to a particular constitutional ideal, rooted to place and sealed by identity. Ignoring his earlier scholarly disdain for nationalism, which he likened to superstition and magic, Trudeau frequently invoked a spirit of what I call constitutional nationalism in his politics of constitutional change. In doing so, he drew on a long tradition in Canadian constitutional politics, culture, and law. Constitutional nationalism has been one of the principal drivers of constitutional change in Canadian history, in my view, and it played a powerful but underappreciated role in the Patriation negotiations. My topic this morning is not those negotiations per se, but rather the ideas that led to their doorstep. It has often been argued that Canada's constitutional history, especially before 1982, was overwhelmingly, if not exclusively, driven by political elites. Ordinary Canadians weren't very interested in the Constitution, Reginald Whittaker has argued, but to be fair, he claimed the Constitution wasn't very interested in them either. This idea of Canada's history of constitutional elitism fails to account for the powerful force of constitutional nationalism, not only among politicians, but also lawyers, scholars, judges, and among Canadians more broadly, in influencing the shape and the texture of Canadian constitutional debates. What I mean by constitutional nationalism will, I hope, become evident over the course of my remarks, but let me say a few words about it at the outset. Constitutional nationalism locates its demand for national self-determination, identity, and ideology in a formal constitution. It takes seriously the legal authority of the Constitution to effect change, but also the symbolic role of the Constitution as an instrument in constructing national unity, identity, and purpose. We have a rendezvous with the British North America Act, constitutional scholar Frank Scott repeatedly reminded Canadians during his long academic career. And of course, he was right. Curiously omitted from the BNA Act was a method of amendment. The lacunae could not have been an oversight. The constitutions of other nations in that period, notably New Zealand and the United States, had included amending formulas. Furthermore, the Canadian framers of Confederation included in the BNA Act a specific provision to allow for the amendment of provincial constitutions. Although the historical records do not fully disclose the framers' motives in this regard. Historians largely agree that the framers simply assumed that the amending formula would be unnecessary, since Britain would continue its historical constitutional role in relation to the new Dominion of Canada. Earlier constitutional acts, the Quebec Act of 1774, the Constitutional Act of 1791, the Act of Union, 1840, had not contained amending formulas either. The expectation was that if change is needed, we'll simply go to Great Britain and change will be provided. And amendments were needed. New provinces were added, seats in the House of Commons and Senate needed to be redistributed, and early efforts were accomplished by appealing to Great Britain just as they had planned. First without Parliament's approval, but very quickly a practice developed of seeking the joint approval of the House and Commons and Senate to give life to the petition to Britain to create the amendment. Sometimes the government of Canada consulted provinces on amendments, and sometimes they did not. But almost from the outset, voices pointed out that Canada should be amending its own constitution. As early as 1883, a Toronto magazine argued that the constitutional power of amendment should be vested in Canadian hands. These arguments were very forcefully picked up by the lawyer and journalist John Skirving Ewart. Canada has commenced, he said in 1904, to believe in herself and to recognize that for her too, there is a principal part to play upon the stage of the world. Canada has become conscious of the feelings and the aspirations, the strong strivings of strenuous nationhood, and, on the other hand, of the utter impossibility of full expression and assertion in mere colonial status. Those aspirations of nationhood, he argued, could be achieved by ending legal appeals to the Judicial Committee of the Privy Council and by taking full control of the amendment formula. On the ground, constitutional change in Canada was already well underway as Canada took its first steps towards constitutional independence from Great Britain. It began to negotiate its own commercial treaties early in the 20th century and develop a small role in external affairs. When the Dominion of Canada signed the Treaty of Versailles in 1919 to end the First World War, many remarked that this was a new beginning in Canada's nationhood. It is no coincidence that the following year, 1920, Mackenzie King, then leader of the opposition, brought the issue of Canada's emerging status to Parliament, pointing out that the letter of the Constitution was at odds with this new spirit of national identity. King recommended work commence immediately on the creation of a domestic amending formula for the Constitution. The process only took the next 61 years to accomplish. Over the next decade, a chorus of voices took up King's demand, most notably J.S. Wordsworth, repeatedly introducing motions to the House of Commons seeking agreement that Canada needed desperately a domestic amending formula. Wordsworth's motives were, he freely admitted, driven by practical politics. He wanted Canadian power to amend the Constitution so that the Canadian Constitution could be amended. But he, like other progressives from English Canada, wanted a more centralized federalism in which economic intervention could constitutionally emanate from the federal government. The old-time constitutional provisions are quite inadequate to meet the needs of the present, he claimed, time and again. If we want to fix an automobile, why should we be forced to go back to the ox cart? But Wordsworth and his growing supporters in and out of Parliament also seized on the Constitution as a symbol of nationhood. And here he was always quick to point out that the Constitution belonged to more than just the lawyers. This was a matter of national, if not individual, self-respect, of growing up, he said, of self-determination and home rule. He didn't use the labels of political science, but he certainly could have. He wanted an autochthonous, how do I say that? Sorry, say it again? Autochthonous, thank you, constitution. They wanted legal form to agree with the substance of Canadian indigenous constitutionality. It was also a question of rights, of it was also a question of rights, a phrase that appears repeatedly in these debates. equality rights with Britain. Why should Canadians not exercise control over their constitutional document as British citizens were able to do for theirs? And why, for that matter, weren't Canadians to have equal rights like other members of the Commonwealth? Australia, South Africa, Ireland, all of those citizens could amend their constitution. Why were Canadians alone on the stage in this, what they called, humiliating status? These were arguments that could and did widely appeal across partisan lines, including among Quebecers, Henri Bourassa among them, as long, they said, as minority and provincial rights could be sufficiently protected. Opponents initially attacked Wordsworth as fanning flames that simply did not exist. These were mere academic questions, they said, which no one in this country is at all interested in. Others stressed the need to retain all ties, constitutional and otherwise, to the motherland, extolling the genius of the British Empire. But these views grew quieter and quieter as the 1920s became the 1930s. Still others pointed out that the current system of seeking amendments from Great Britain actually worked pretty well. Why should we fix what wasn't broken? As the debate continued, others began to wonder whether the power of constitutional amendment wasn't itself just a little bit dangerous. Would Parliament be in a position to alter the division of powers to the detriment of the provinces, they asked? No, Canada is not a sovereign state, a Toronto MP declared, and it is a good thing that it is not. Confederation was a hard-earned compromise. Better not to reopen the bargain, lest consensus and compromise and cool heads fail us this time around. And yet the issue simply would not die. Debates on the need for a constitutional amending formula resurfaced throughout the 1920s and 1930s. In 1927, an exasperated Robert Mannion, representing my old hometown of Fort William, Ontario, complained of constitution mongers. People who are so worried about the constitution of our country, so worried about the autonomy of Canada, so afraid that we are subservient to some other part of the empire, that they wish to talk of nothing else. Nonetheless, these constitution mongers were growing louder. Disenchantment with the Privy Council continued to grow among constitutional scholars, especially after the Privy Council decision striking down Canada's legislative attempts to ban appeals to that body. In addition, the Governor-General's refusal to follow Mackenzie King's advice in the famous King Byng affair emboldened those who claimed that there was now a need more than ever for greater constitutional independence, Mackenzie King chief among them. The growing spirit of constitutional nationalism led in part to the Balfour Declaration, which emerged out of the 1926 Imperial Conference, proclaiming that Canada and the other dominions were autonomous communities within the British Empire, true, but equal in status, in no way subordinate to one another in any respect of their domestic or external affairs. That Declaration of Autonomy was legalized in the Statute of Westminster, 1931, which ended the reign of British Parliament over Canadian legislation, except, and this is a big exception, for the Canadian Constitution. At the precise moment when consensus coalesced around the idea that Canada needed to amend its own constitution, a new crisis of disagreement emerged. Just how should that amending formula work? What would it look like? Was Confederation a contract? Was it a treaty? Was it a compact in which the original colonies were able to veto any proposed alterations? What should the role of the provinces be that had joined Confederation since 1867? Should some features of the Constitution be amended simply by Parliament alone and others with provincial consent? If so, which ones? How much consent was necessary? The historical record offered no clear set of precedents, and the Dominion provincial conferences in 1927, 1931, 35, 49, 50, 60, 64, you get my idea, and half a dozen others failed to find agreement among governments about how to amend the Constitution. But by now and despite these failures, constitutional nationalism as an idea, which had become orthodoxy in the House of Commons, had spread beyond the limestone walls of Parliament. Canada's constitutional status became the pressing constitutional issue and dilemma for a generation of constitutional scholars. W.P.M. Kennedy, the influential constitutional historian and law teacher at the University of Toronto, Frank Scott at McGill, Vincent MacDonald at Dalhousie, among several others, issued the same battle cry in the classroom, in the law journals, and whenever they gave free lectures and addresses to the public on this topic, of which they did often. They said, number one, Canadian constitutional law had its own unique, distinct purpose, identity, and destiny. Two, appeals to the Privy Council must be abolished to allow that destiny to be fulfilled. Three, the Constitution must be changed to meet new theories of government. And four, a domestic constitutional amending formula was needed for both symbolic and functional value. With minor variations, these scholars made these arguments again and again. And just to be sure, they made them again. Lawyers and judges reading the Canadian Bar Review and in Quebec the Revue de Barreau might have grown tired of the repetition, but they could not have failed to notice that the issue mattered to lawyers. Certainly the Privy Council noticed. In 1935, they readily fell on their own sword, pronouncing that after the Statute of Westminster, Canada now fully possessed all the constitutional authority. Indeed, they used the word sovereignty to end appeals to the Privy Council, and they did so again a decade later on the issue of civil appeals. A generation of Canadian lawyers, many of whom went on to work in government and in Parliament, was reared on the teachings and the convictions of these scholars, including two men who we'll hear about later, Laura Laskin and Pierre Trudeau. But did the public care about any of this? Well, it's my position that they did, although it's always difficult to gauge these kinds of things from the future. 50 years from now, I think there'll be a conference where did Canadians care about the prorogation crisis of 2009, so you should book your calendars. Politicians, for their part, then as now, claimed that either the public cared deeply about this, they were in an existential crisis, this needed to be addressed immediately if you wanted an amending formula, or that Canadians couldn't care less. I've traveled the country and I've never heard anyone mention this to me if you were against the idea. But given the perpetual reappearance of this issue in Canadian politics, most Canadians could not have but confronted the various circulating arguments about the relationship between nationhood and the Constitution. Newspapers, of course, covered these parliamentary debates, and they framed them in constitutional terms, just as they did their coverage of the King Byng affair, the Balfour Declaration, and the Statute of Westminster, and all of the politics surrounding the Privy Council. Editorially, the influential Manitoba and then Winnipeg Free Press championed the cause of constitutional nationalism. But most papers, including Le Devoir, at one time or another exhorted politicians to find a domestic amending formula to bring the Canadian Constitution home. It's true that this issue played out more strongly in English Canada than in Quebec, but in Quebec too, there were eloquent testimonies to the need for domestic amending formula. Jean Lesage made a number of speeches in Parliament on the need for a domestic amending formula, a new constitution, and an end to Privy Council appeals. While it is true that no election turned directly on the issue, and it is true that Canadians had plenty of other things to worry about during these years, economic crises and war justifiably dominated public policy, but Canadian politics, whatever the topic, had a habit of tracing back to the Constitution. The Great Depression was cast as a failure of the Constitution to enable sufficient governmental response. And the Second World War was a fight for the freedoms that the Constitution provided. Writing for a little-known magazine, Canadian Affairs, a wartime publication for Canadians serving overseas, I. Norman Smith, an editor of the Ottawa Journal, said that if a sergeant really wants to get his barrack room quickly emptied of all of its men, he doesn't need to lure them out with free drinks. He just needs to announce that there's a professor coming in to talk to them about the Canadian Constitution. That quote keeps me humble. But next, he said this. He said, "You might argue that Canadians are fighting this war to protect their Constitution. But if you thought it over, you might change your mind. The thing Canadians are really fighting for is the right to do what they want with their Constitution. In Nazi land, Hitler decides what the Constitution is to be. In Canada, the people decide." If the right of the people to control their constitutional destiny was worth fighting and dying for, surely it was worth the effort to cross the divides between political parties and across governments. The ideals of constitutional nationalism established from the 1920s to the 1950s provided the unseen foundations for the patriation politics that followed by creating a consensus, not about the particulars, and indeed the particulars of course mattered, but about the ideal, about what it meant to be a country. But of course, the success of that ideal is a mixed one. As happy as many of these early voices would have been with the Constitution Act 1982, I think there would have been some disappointment too, that some of the dangers that their critics had warned of had indeed come to pass. Thank you very much.
Our second panelist is David Schneiderman. David is a professor of law at the University of Toronto, where he teaches courses in Canadian and American constitutional law and on international investment law and law and globalization. David is also, many of you may know, the first director of the Centre for Constitutional Studies at the University of Alberta, and those of us involved with the Centre and its publications are very aware of the vision that he and others inspired at that time and the legacy that he left. So I'd like to welcome David to the podium for his paper entitled Trudeau's Constitutional Vision. Thanks.
Thank you very much. It's a real honor to be part of the program and a real pleasure to see some old friends. The subtitle of my paper, not in the program, is the title of the paper is The Judicial Role in Trudeau's Constitutional Vision, and the subtitle of the paper is Or What Me Worry? To what degree, if any, did Pierre Elliott Trudeau think about the role the judiciary inevitably would play in interpreting and applying his Bill of Rights? Did the judiciary have any place in his constitutional thinking? Are there elements of his constitutional theory analogous to those found elsewhere? What I offer here is a constitutional lawyer's paper asking of another constitutional lawyer, what did you think about judges? It's a boiled down version of a longer paper that's very preliminary and tentative, so I welcome comments. So let me begin with two quotes. The first is from Trudeau's speech in 1967 to the Canadian Bar Association, entitled A Constitutional Declaration of Rights. In this area, he said, more than any other, one must know where policy leads. That is constitutional policy. The second quote is from one of our co-conveners, Howard Leeson, recalling the events of 1981-82. He says, what was missing was the broader political discussion in Canada of having the desirability of a court-administered society, a court judge-made law. The first quote, initially written by Carl Goldenberg and then revised extensively by Trudeau, signaled that constitutional reform would be thought of in realistic terms. Constitutional reform, as Trudeau would put it later in that 1967 speech, would be one of, quote, controlled development, but without fear of change. An immediate and easily identifiable consequence of entrenching a Bill of Rights would be to hand over a large swath of policy authority to the judicial branch. And surely this would be an important consideration for any constitutional law thinker. The second quote, at the level of a public discourse, Leeson's quote suggests otherwise. Premiers Blakeney and Lyon placed the question of the legalization of politics firmly on the table during the discussions, but this appeared to have little place in public debates leading up to patriation. Indeed, the federal side preferred to elide this question entirely. Curiously, few scholars have taken up discussing this judicial element in Trudeau's constitutional thinking. Typically, there's assumed to be some implied but never fully worked out constitutional theory of judicial review at work. Scholars point to the constituent elements of Trudeau's project: entrenched bilingualism, some form of mobility rights, both of which happen to be excluded from the scope of Section 33, the notwithstanding clause, but then they do little else. I found only one serious treatment of the subject, and it happens to be by my colleague Lorraine Weinreb, who draws out a full-blown constitutional theory from a 3-page book review Trudeau published in 1963. The theory, as she describes it, is a rather paradoxical formulation that looks something like this. By entrenching a Bill of Rights, provinces would be free to exercise their autonomy with more freedom, that's Trudeau's word, by acting within the bounds of the civilizing constraints of rights. It's also a rather slippery formulation because it moves between the constraints of federalism and a Charter of Rights as if they were equivalent, and they're not. The first divides authority and the second removes authority altogether. One of the reasons the subject hasn't been given more serious treatment are the paucity of references to judicial interpretation in Trudeau's public writing and statements. There's famously the observation in his 1965 essay, Federalism, Nationalism, and Reason, that if the Privy Council had not, quote, leaned in the direction of provincial rights, Quebec's separatism would be an accomplished fact, as he put it. But there's little else. What I want to argue is that he did not give much thought to the question, as the reference to Alfred E. Newman suggests, what me worry. He didn't worry about it. The success of his project would not turn on this or that judicial approach to interpreting the Charter's terms. Rather, the project was about radically altering the minds of men and their philosophies, as he put it. Establishing a new Canadian identity was his criterion for success. Yet he would have had good reason to worry about judicial interpretation. Any good social democrat, as Alan Blakeney would have reminded us, would be anxious about courts standing in the way of progressive social change, just as the United States Supreme Court had in the period we associate with the famous Lochner case, where the U.S. Supreme Court struck down a New York state law setting limits on the hours and days of bakery workers for being contrary to the 14th Amendment to the U.S. Constitution. Trudeau's mentor at the London School of Economics, Harold J. Lasky, expressed such reservations in his book, A Grammar of Politics. Though Lasky acknowledged that individual rights were key to democratic life, and he devoted the 3rd chapter in this important book to the topic of rights, he was cautious about entrenching a Bill of Rights, as they act, and these are Lasky's terms, they act as a serious lever against what may well be desirable change. Written constitutions, he wrote, always reflect the spirit at the time at which it is made, and the judge will more perfectly respect that historical spirit than those of some novel ideology like socialism. From this perspective, it made little sense to allow judges' views to prevail on, for instance, questions of pressing economic legislation, as they are no more likely to be right, Lasky wrote, than the legislature. Now, Trudeau admitted to having read A Grammar of Politics, which he describes in his memoirs as an encyclopedic work that, for some unknown reason, no longer gets any attention. And he also admits to having been greatly influenced by him. Yet Trudeau exhibited little interest in this judicial capacity to stifle legislative innovation, despite his mentor's preoccupation with it. There are, of course, currents running in the opposing direction that help to explain this absence. And here's a list of these opposing, countervailing currents. First, Trudeau's constitutional ambition was Quebec-driven and Quebec-focused. The project emerged out of a Cité Libre's narrative about the French-Canadian role in Canada, and there appears to have been little thought devoted in these circles to the question of judicial politics in the realm of rights. Aside from the suspicion that the Supreme Court of Canada leans in a federalist direction, this is a tradition, I think, that carries on in Quebec today. Second, there is Professor Frank Scott of McGill University, described as a great hero by Trudeau, who may also have played a role. Scott, a founder of the League for Social Reconstruction and the Cooperative Commonwealth Federation, forerunner to the NDP, had been advocating for an entrenched Bill of Rights since the League's foundational book, Social Planning for Canada, in 1935. Scott knew of the American experience under Lochner, yet chose to will away that experience. Eric Adams has written the definitive work on this, rather underexplored facet of Scott's thinking. Trudeau similarly willed away the controversy. At the February 1968 Constitutional Conference in Ottawa, he admitted that initial opposition to a Bill of Rights was based upon the American experience. We are aware of some of its shortcomings, he declared. I simply say that the American precedent with respect to those shortcomings is not valid in Canada. Though Scott had a different view about the merits of provincial autonomy over property and civil rights, Scott and Trudeau would make common cause in a Bill of Rights project. Third in this list of countervailing currents, Trudeau, much like our current Prime Minister, admired the United States constitutional system. In that same 1968 conference in Ottawa, he declared that, quote, "It would be most unfortunate if our criticism of some aspects of American society caused us to forget that there has been created in the United States one of the great legal systems of the world." And there are other references like this. This admiration reached its apogee, according to André Burel, in a draft 1980 preamble beginning with, "We the people of Canada." Trudeau described this preamble as, quote, "pretty hard to beat," in his submission to the Senate of Canada on the Meech Lake Accord. Trudeau was not overly concerned then with the influence of that elephant to the south in constitutional matters. We might conclude that in some respects he welcomed it. Fourth, Trudeau was importing into Canada constitutional ideas that originated not only in the United States, but also in the 1789 French Declaration of the Rights of Man and the Citizen. The 1789 Declaration would have prompted little thinking about the judicial role, as there was no US-style judicial review by the Conseil constitutionnel until 1971. Nor for this reason would the personalism a philosophy of Emmanuel Mounier have inspired much deeper reflection on the judicial role under a Bill of Rights. Fifth, if, as Alan Cairns has reminded us, the rise of international human rights has a role to explain the Charter's genesis, Trudeau would have learned little about the judicial function from this system of rights. As David Kennedy reminds us, the international human rights movement propagates, in his words, unduly abstract ideas. And these can be used for all variety of purposes. There's little experience in that system with meaningful mechanisms of enforcement or with judicial authority. Sixth in this list of reasons, the record reveals mostly simplistic explanations of judicial interpretation that seem more opportunistic than realistic. And this was made most evident in Trudeau's powerful interventions into debates over the Meech Lake and Charlottetown Accords. Not wanting to revive those old debates here. Perhaps Gordon Robertson goes a little too far when he says that Trudeau offered, quote, "no legal analysis whatever." But he's not that far off the mark. Setting his sights on the Distinct Society Clause, Trudeau could barely admit that whatever its effects of the Distinct Society Clause, those effects would be mitigated by a non-derogation clause on federal power. Indeed, in the years 1981-82, Trudeau would resort to what, in my view, are crude and simplistic formulations. He would say almost anything in order to undermine the legitimacy of the recalcitrant premiers making up the Gang of Eight. In the acrimonious 1980 First Ministers' Conference, Trudeau disingenuously compares provincial statutory human rights codes with his proposal for an entrenched Bill of Rights. And this is a mistake that Ron Graham repeats in his recent book on these events. They're, of course, not equivalent. This isn't to say, however, that Trudeau didn't care about judicial authority or judicial functions. His appointment of Bora Laskin, Laskin's subsequent elevation to the Chief Justiceship, and Phil Gerard's paper will speak to these points. His hope that federal power might be vindicated in the anti-inflation reference, and his subsequent anger about the patriation reference all point to the degree to which Trudeau appreciated the importance of judicial power in a constitutional democracy. But prior to the patriation reference, there's not a lot of evidence that judicial lawmaking, which is how he described the Supreme Court decision in the patriation reference in his famous Bora Laskin Library speech, there's no evidence that judicial lawmaking had previously been a concern. Nor is this to say that Trudeau was not responsive to worries about judicial activism running amok under a carelessly drafted charter. Here, we might say he was faithful to the approach he was advocating in his 1967 Canadian Bar Association speech, attentive to the consequences of using one term over another in the cause of advancing his Bill of Rights. Early on, Trudeau acknowledges that the phrase due process of law had in the US created, quote, many problems because of its vagueness, and so eventually adopts the perhaps no less vague phrase fundamental justice in Section 7 and abandons a proposed property rights clause. And both of these moves, I think, speak to concerns about drafting of the charter. How then to describe Trudeau's constitutional theory and the judicial role within it? Some have chosen to draw analogies to Jürgen Habermas's constitutional patriotism, which is meant to describe the European unification project. And this, I think, is echoed in Eric Adams's description of constitutional nationalism. To the extent that Trudeau's nation-building exercise was about countervailing the centrifugal forces of Quebec nationalism, the European analogy, I think, is appropriate. It's appropriate to talk about Canadian nationalism, and constitutional patriotism. But this approach blurs the judicial role that I want to emphasize here. In the paper, I take up a Madisonian view of rights. Stripped of James Madison's departmentalist or coordinate branch view, which saw the judicial branch as not having a capacity to bind the legislative and executive branches. So strictly 18th century idea. So bracketing then James Madison's departmentalism, a Bill of Rights for Madison served important educative and cultural functions. Madison was initially ambivalent about attaching a Bill of Rights to the 1787 U.S. Constitution, for fear that it would imply federal authority where none had been granted in the list of federal enumerations. He came around to endorsing one during the state ratification debates and after committing to a Bill of Rights during a hotly contested race for a seat in the House of Representatives. When can a Bill of Rights serve in popular governments? Madison asked Thomas Jefferson in a 1788 letter. First, or more importantly perhaps, and this is Madison writing, when the political truths declared in a solemn manner in a Bill of Rights acquire by degree the character of fundamental maxims of free government, and as they become incorporated within the national sentiment, counteract the impulses of interest and passion. And furthermore, whenever there's a danger of oppression that springs from government action, a Bill of Rights, he writes, would be a good ground for an appeal to the sense of community. He observed, however, no tendency in our governments to danger on that side of acts of tyranny springing from government, John Adams had not yet assumed the presidency. So a Bill of Rights for James Madison was not a binding set of rules, but a set of values that would gradually be internalized by the whole of society. Trudeau, of course, did not think that the Charter was self-executing, the rhetoric of the People's Package suggesting otherwise. He well knew that the judicial branch would be called upon to resolve vexing rights questions that had no obvious legal answer, but that would require the weighing of complex policy solutions. The risk of judicial politicking, however, was not considered intolerable by him. There was, more importantly, the prospect of changing hearts and minds, of adjusting constitutional culture so as to counteract what Madison called and Trudeau would later echo the impulses of interest and passion. Bruce Poe reports that Trudeau, in a telephone conversation touching on the Charlottetown Accord, said to Poe, "The point is, don't stop change by putting us in a bind with these deals." Poe is attracted to the powerful idea of openness, which he associates with Trudeau's just society. Imagine an era, Poe writes in Mystic Trudeau, where everything is possible because everything is open. It's curious that both Poe and Trudeau exempt the 1982 constitutional exercise from their consideration. To the extent that this was a project that put us in a bind, intended to shift constitutional culture, determining the shape and direction of constitutional politics ever since, will not have succeeded in achieving an openness where everything is possible. They would have been better advised to read or reread Lasky's Grammar of Politics. In contrast to what he described as the draining effect of a Bill of Rights on political life in the United States, Lasky reflected on the beneficial effects of the English constitutional system, which appropriately describes the Canadian one as well, pre-1982, which makes for a flexibility that has enormous advantages in a period of great social change. It means that new ideas can make their way without being compelled to pass through the complicated sieve devised to protect ideas deemed fundamental by an earlier period. Even if the Charter's notwithstanding clause was intended to preserve this flexibility, we know there's no going back, reverting to an age without entrenched rights. It's an impossibility, and one that, in the pursuit of the project, has put us legally and politically in somewhat of a bind. Thank you.
Somewhat of a joke, I want to thank the organizers of inviting me here in Edmonton. Counting correctly, I hope, now I've been invited more often by the Center of Constitutional Studies, Faculty of Law, and Department of Political Science at the University of Alberta than by my former colleagues in the Department of Political Science at the University of Calgary. So whatever you want, just tell them. 10 years ago, I was in Ottawa with Roger Tassé, who's here, and the late Gérald Baudouin, for a conference organized by the Department of Justice of the federal government in an entirely different political era, the Liberals in power forever, or so everybody believed, on a conference for the 20th anniversary of the Charter. 5 years ago, with a number of people in this room, I was at McGill for a conference on the Institute of Canadian Studies at McGill on the 25th anniversary of the Charter. And here we're gathered today for the 30th. For a Quebecer of my views, on the whole, those are unhappy circumstances. And I'm not particularly masochistic in terms of personal orientation. So let's cut a deal, okay? So after 20, 25, and 30, if there's another conference, not before 20 years. You know. Some other elements of my introduction, I could have had other titles, Reason and Passion. Where is reason and where is passion? With regards to Pierre Elliott Trudeau. I'll come back to this in a moment. Another possibly hard-edged title would have been Disallowance by Other Means, how the Canadian majority abused its powers in 1981-82, and I'll come back to this as well later on. In my presentation, there is one hero and many villains, and some of them in the room. And this is it. I'm not going to talk about just nice things for 2 days. I mean, there's got to be some serious stuff here. The hero is still living, and his name is André Burrell. Many of you knew him. He was a player, although a minor one, in the constitutional era. He was an advisor and a speechwriter for Pierre Elliott Trudeau between 1977 and 1984. And he wrote 2 books, which I'd ask David to just pass me, because I'll need it for a quote later on, entitled Pierre Elliott Trudeau, l'intellectuel et le politique, in 2005-2006. Now, many of us work with editors and we publish stuff and so on. And what a great sign this would be of the quality of our conversation about these things if this book would be available to most of you in English. Okay? It's just a pity that Burrell's work has not been translated and is not available to you for reasons that I hope I'll make clearer. So let me go to the heart of the matter, using Burrell as my hero and the leitmotif for my whole presentation, which will, I hope, have about 4 parts. The one that I'm about to start, which is going to be short, which is the essence of the matter, those negotiations, what were they part of, 81-82. I'll follow up with an analysis of how Quebec behaved, how the Quebec government behaved after the referendum of 1980, leading to the negotiations. And then I'll come back to Burrell to try to follow with him what were the reasons for the type of attitude that Trudeau developed, essentially after the conference of September 1980. Many of you in the room will remember that, the failure of the September 1980 conference, leading to, according to Burrell, a change of attitude, a change of perspective, which on the whole has been neglected in the literature. I have Peter Russell here, not too far from me. I have read most of the stuff, not everything. I haven't read Ron Graham, but I've read Clarkson, I've read all kinds of things. And the shift in Trudeau's mind that occurred, according to Burrell, on the whole is not totally absent. McRobert talks about it, but on the whole, not very present in English-Canadian constitutional historiography. I'll talk about language and then conclude. So what happened in November 1981, according to Burrell? So the essence of it, what happened was a meeting of minds, an encounter between 2 things. One, so that this is after September 1980. One, an encounter between Trudeau's one nation, liberal individualism. So one half of Trudeau's mind, as you'll see in a moment. Burrell, in a way, represented the other half of Trudeau's mind. The couple reason and passion within Trudeau himself, which survived very late into the game, which was present at the time of the referendum, present, according to Burrell, as late as the famous September 1980 conference. So one half of Trudeau's mind, one nation, liberal individualism, sort of continuation of what Eric Adams told you about. Trudeau in line with the constitutional nationalism of English-Canadian historiography. But then the encounter with what? Precisely. The need felt, according to Burrell, in many quarters in English-speaking Canada, but also in some parts of Quebec, F.R. Scott came from Quebec, to found anew on a civic basis the old English-Canadian loyalist Canadian nationalism. And that's what happened in 81-82, and that's what happened particularly 30 years ago at that constitutional negotiation conference. So to Burrell, this is the heart of the matter. If we had more time, we could locate that more precisely in our double historiography, Quebec intellectual history, English-Canadian intellectual history, how they've moved, how they've talked to one another over time. So we'll leave that for some of the day. Before I go more into Burel, let's look at Quebec. Let's look at the performance of the Quebec government after the referendum of 1980 until the conference of November 1981. Let's look at the performance of Quebec. Before I do that, let me do a pro bono approach and summarize my scholarship on these things with 2 points. First one, for 40 years, let's say between 1960 until post-Charlottetown, late 1990s, most textbooks of Canadian political science say that really, what really drove change, the motor, the dynamism of change into the Canadian constitutional order came from Quebec. In my words, the formidable pressures placed on Canada by the Quebec of the Quiet Revolution and also by the sovereigntist movement. That's my first point. And this was behind as well, 81, 82. My second point relates our 19th century history and our 20th century history. I call the rebellions of 37-38 the failed rebellions of the imperial age. And I call the referendums of 1980 and 1995 the failed rebellions of the democratic age. Now, when you organize referendums, believing that you'll be stronger if you win, logically, you should accept that whatever the result, you'll be weaker if you lose. And by you will be weaker means the individuals, their political movements, their parties, and the whole society. So Quebec on the whole was weaker after the referendum of May 20th, 1980. And it is with this weak set of cards in his hands that René Lévesque embarked upon the round that led to the early November 1981 Constitutional Conference. With this weak set of cards, you could say, this is my judgment, preliminary, that Quebec, Robert Normand is here, some people dealt with them, you can evaluate them yourselves, and you'll talk to us about that over the next couple of days. But in my judgment, on the whole, Quebec deserves a B+ or an A- on two things. We're teachers first and foremost. We give marks. First one, on the whole, with a weak set of cards in his hand, having been weakened by the results of the referendum, and being a sovereigntist in a round that has to deal with renewed federalism, Lévesque and his players, his bureaucrats and his ministers, on the whole, entering into talks with other governments after May 1980 till November 1981, played reasonably well. They were able to diminish the rhythm of the federal offensive. They made deals with one another. I'll come back to them in a moment. But on the whole, they maintained an alliance, however uneasy, with players that had their own sets of objectives and the sorts of compromises they wanted to make. So on the whole, Quebec played reasonably well with its weak set of cards, entering into deals with others after the referendum of May 1980. The second place where I'd give Quebec a very good mark is with regards to the relationship with the British government. How Quebec, but not only Quebec, the other provinces in the Gang of Eight, played the game in London with the British government, understanding the rules of the game, understanding where they could find support, in a way at the margins, but also in some instances at the very heart of the British system of government. We speak French in Quebec. As the Edmonton Sun recalled everybody yesterday, we were the French fanatics, as the Edmonton Sun mentioned. But although we speak French and owe a lot to France, our political culture is deeply British. And because of that, Gilles Loisel, the delegate of Quebec in London, fully understanding the political culture in question, with others played it very well. So those are the good points. Rapidly, the errors, the mistakes that were made by Quebec. This will just be an enumeration for most of them. I'll have other opportunities to go deeper. First mistake, after the referendum, the failure to integrate Claude Ryan. Renewed federalism was embodied by Claude Ryan in Quebec. We know on the record that it took almost a year after the referendum for any meeting to occur between Lévesque and Ryan. This is catastrophic. After the election of April 13, 1981, which brought Lévesque to re-election, three days later, there was a deal that was made with the provinces, a deal that, in which Quebec more or less unilaterally renounced the idea that it had a veto in constitutional matters. So Quebec misplayed that card. And it's easy for an observer to say that a posteriori. I recognize it fully. Nevertheless, Quebec could have said something like this to its partners. We agree to be bound for the future by something like the amending formula we're discussing. However, although we agree to be bound by that in the future, within the current system, we believe that we have a veto. So Quebec mismanaged the issue of the veto. That's my second point. Third, Quebec did not play well the judiciary card. Its factum to its own Court of Appeal, its position, its decision not to go immediately to its Court of Appeal following the September 28, 1981 decision, which talked about a substantial degree of provincial consent. Immediately, Quebec should have gone to court, asking what did that mean and whether or not it meant that Quebec's consent was required. Many people, including Donald Smiley, believed that Quebec's consent was required, by the way. Quebec did not use the right arguments when it went to courts. Quebec could have used other arguments. Well, if property and civil rights are touched by this, as the Court of Appeal of Manitoba said, if, as the Supreme Court reference said, property and civil rights are touched, then why don't you plead Section 94 of the Constitution Act 1867? Quebec didn't do that. We know from André Burel that the federal government was not fearful, this would be exaggerated, but was concerned about the possibility that Quebec could use the referendum to go against unilateralism in the fall of 1981. So Lévesque did not play the referendum card, did not play the democratic card against the federal project. I could go much longer. I'm watching my time with regards to how Quebec behaved during the negotiations, during that fateful week, November 1, November 5. So I have half a dozen points here. I'll just mention one. I'm looking at my watch. We're in the West. It's 10:05. So exactly 30 years ago, by the minute in the East, it was noon. And Lévesque was about to fall into Trudeau's trap. You, René, the great Democrat, you'd agree, wouldn't you, to the idea that we should go to the people. And Lévesque, I'll buy that. Lévesque sort of unilaterally opening a space for the other provinces to deal behind his own back, as they did later on. To their shame, but that's a different point. So, all in all, Quebec, with some good shots, didn't play that well. Back to Burel. Reason and passion, that's his first point. The shadow consensus of September 1980 in the context of the Constitutional Conference according to Burrell, is the pretext. Trudeau moved to unilateralism. Trudeau abandoned one half of his soul and decided to go with the project of one nation, symmetrical rights, individual rights, first and foremost, after the failure of that conference. And the idea that the provinces had once again, with the leadership of Quebec, banged together to organize something, as the expression was used, a confederation of shopping centers, to use his language. Okay? But that's the pretext, according to Burrell. The real stuff is elsewhere. The reasons why he moved in that direction, abandoning the equilibrium in his mind between what Burrell called le personnalisme communautaire, communitarian personalism, the idea of cité libre, of Mounier and Maritain, which were the reason in Trudeau's mind. The passion was liberal individualism. His epiphany when he was 30, when he discovered this in the late 1940s at about 30. Okay? So this equilibrium in his mind between these two strands of his thought, according to Burrell, this equilibrium stayed beyond the referendum of May 1980. It's present in Trudeau's speech of May 20, 1980. It's present in some of the federal propositions as late as September 1980. Trudeau was willing to accept something like Meech Lake's Distinct Society Clause for Quebec. But after September 1980, that half of his mind, according to Burrell, disappeared. Why? The strength of his passion, one nation, one Canadian nation, with symmetrical rights for everybody, with individual rights and language rights as part of individual rights. That imposed itself on his mind, a rupture of the equilibrium of his soul. That's Burrell's first reason. Second reason, Burrell calls this the crisis of the old loyalist English-Canadian nationalism, which was brewing for some time, which was present in the first half of the 20th century, but which was evident to everybody in the intellectual world of English-speaking Canada in the late 1970s. Canada needed something else. And Trudeau's vision, one nation, bilingual, multicultural, made a lot of sense in those circumstances. Third reason, some of them are present in this room, according to Burrell, a change of guard in his advisors. Trudeau's advisors changed for that round. Robertson was skipped aside. Burrell himself and a group formed by, let's give their names, Michael Pitfield, Michael Kirby, Jim Coots, Tom Axworthy, and Trudeau's other speechwriter representing one half of his soul, Jim Moore. So that changed the game. No more Pelletier, no more Marchand. The communitarian personalism side of Trudeau's mind disappeared at that time. I mean, although he broke his political friendship with Trudeau, Burrell remains a personal friend. He talks in tremendously impressive language about the loneliness at the heart of power that Trudeau had to feel. Struggling with his own soul in all these projects, with all the memos coming to him, when he's overburdened. And at some time, he decides to make peace with himself, according to Burrell, but by abandoning one half of his soul. Political fortuna, the fifth reason. Politics is at times about luck, about chance. Joe Clark making the blunders that he made. Lévesque beating Ryan. Trudeau coming back in February 1980 with a majority, whereas during the campaign he hadn't talked about constitutional issues. Whereas in 1979, he was beaten after talking a lot about constitutional issues. So, luck. Sixth reason, according to Burrell, the inevitable polarization of political debate. And at this, according to Burrell, Trudeau